In the case of the Assin North MP, his appeal was for a stay of proceedings after the trial judge, Justice Quayson, dismissed earlier appeal for stay of proceedings. Unfortunately for him, the appeals court he turned to also dismissed the application. Counsel for the petitioner raised a preliminary objection to the motion for stay of proceedings on the grounds that the Court of Appeal lacked jurisdiction to grant motions for stay of proceedings since CI 132 has revoked Rules 27A and 28 of CI 19, which were the rules upon which the Court of Appeal could grant an application for stay of proceedings. Counsel for the Assin North MP, Justin Teriwaja, argued the Court of Appeal's power to stay proceedings doesn't mean that it can no longer grant application for stay of proceedings. He further submitted that it only means that the court's power to grant application for stay of proceedings is now based only on the inherent jurisdiction of the Court of Appeal. The panel of 3 judges unanimously dismissed the application of the applicant for stay of proceedings. The judges then advised the Assin North MP to test the law at the Supreme Court in respect of his contention that despite the revocation of the rules, the Court of Appeal still has inherent jurisdiction to grant motions for stay of proceedings. The MP for Jomoro, on the other hand, had also filed an application to stay execution of the High Court's order on her to produce document evidencing the renunciation of her alleged Ivorian citizenship. Lawyer for the Jomoro MP, Godwin Eduji Tamaklo, says his client, the MP for Jomoro, has never pleaded any such document, so the High Court erred in ordering the MP to produce a document which the MP never pleaded. The Court of Appeal subsequently dismissed the appeal, directing the applicant to apply to the Electoral Commission of Ghana for a copy of the statutory declaration she attached to her document when she filed her nomination to contest the election. Representative of the applicant in the Assin North MP's case, Richard Tichimensa, says his opponents are only seeking to drag the process.
We know from day one that we put a solid case before the courts, and they are going to determine the case on its merits. But from day one, the MP for Assin North and his lawyers have been employing delayed tactics. So even when they know that the application is not granted in law, they will still embark on it just to delay the case. But as I've said some time ago, and it's been said over the years, the wheels of justice grind slowly, but it shall definitely get to its destination. So tomorrow too, we are going to the Supreme Court. They filed an application there for certiorari and interpretation, and that one to appearing before the Supreme Court tomorrow.
The Supreme Court is scheduled to give its ruling on Tuesday in an application filed by the Assin North MP. The MP invoked the supervisory jurisdiction of the Supreme Court on the interpretation of Article 94(2)(a) and to quiet the orders of the trial court judge because, according to the MP, the judge did not allow oral submissions in the case before him. Meanwhile, the High Court in Cape Coast has slated Wednesday, 28 July, for the judgment in the Assin North MP's case. For Joy News, Richard Gyaakye, Cape Coast.